Today, during closing arguments in trial, I was sitting and watching a case, and I saw an attorney do something very, very smart that most attorneys would not do. Would you like to know what this is about? I am Gerald, a New York medical malpractice and personal injury attorney. This was a medical malpractice case, and now the defense lawyer who represented the doctors who were being sued, was giving closing arguments. The defense in New York goes first in order to give closing arguments, and this way the plaintiff, the injured patient's attorney, gets the last word. Now, while I'm sitting in the back of the courtroom, I heard the defense attorney say something that clearly should be objected to. It was something inappropriate, and it cast doubt on the veracity, on the credibility of the injured patient here. In most cases, the injured patient's attorney would jump out of his seat as if an ejection button had been pressed, yell out, "Objection, Judge! That's totally inappropriate. I want it stricken from the record. I'd like the jury given an instruction that this is inappropriate and defense counsel knows better." That's what most attorneys would do. In this instance, the plaintiff's attorney, the injured patient's attorney, sat there quietly and didn't say a word. Now, why did I say at the very beginning of this video that that was the right thing to do? That was appropriate. I'll tell you why. If the attorney were to have gone ahead and made a big deal about what this defense lawyer said and interrupted him, now, what do you think happens? Now it focuses attention on that incorrect statement. It focuses attention on something that the attorney did, which I believe was really bait. I think he was baiting the patient's attorney to go ahead and do this, to interrupt him so that now he could make a little speech in front of the jury explaining why, since this is closing argument, he has every right to comment on the evidence in the case. And now, rather than simply disrupting him and creating this whole big stink and issue and objecting to what this attorney said, the plaintiff's attorney sat quietly and waited his turn. And why is that the right thing to do in this particular case? By not making a big stink about it at the moment it's happening. The jury may not truly understand what just happened and what he said was really inappropriate. It's just going to gloss over. But now, when the attorney who represents the injured patient gets up to give his closing arguments, he can certainly comment on what the defense lawyer has said to disparage his own client. He can do that. And that's the appropriate time to do that. Now, there is one drawback to waiting until that happens. And the drawback is that if this is a really significant issue, if this is a significant problem that might actually prejudice the jury and now force them to come to a conclusion that they might not otherwise have reached, if the attorney fails to make an objection at the time it happens, now he is deemed to have waived his right to object to that if they lose the case and now has to appeal. So the injured patient's attorney now has to understand and make a quick decision about whether or not to stand up and object and disrupt the proceedings, which typically during closing arguments is not done or it's kept to a minimum, or to allow it to occur and simply commented on it when he has an opportunity to go ahead and make closing arguments. Want more information about how these cases work in New York? Follow me. Have questions about your matter? Well, if your matter did happen in New York, but you have not yet started a lawsuit and are thinking of doing so, I invite you to pick up the phone and call me. I'm Gerald Oginski. Have a fantastic day.